Welcome to my channel where we discuss everything and all things politics, especially about the 2023 presidential election that was held on February 25, 2023, and the result controversially announced on March 1st, 2023, in which Aswaji Bola Ahmed Tinubu, the presidential candidate of the ruling All Progressive Congress, was declared the winner of the election. His opponents, not satisfied, they headed to the Presidential Election Petition Court to seek redress. Unfortunately for them, the Presidential Election Petition Court ruled in favor of Tinubu, saying that he was validly elected president. Not satisfied, the petitioners have headed to the Supreme Court, which will eventually determine who actually won the 2023 presidential election held in Nigeria on February 25. Now, while matters are happening at the Supreme Court or the courts in Nigeria, another matter is also happening at the court in the United States, in the Northern District of Illinois, in Chicago, where former Vice President and the presidential candidate of the People's Democratic Party, Alhaji Atiku Abubakar, was seeking the academic records of Bola Ahmed Tinubu, and he was seeking the court to compel Chicago State University, which Tinubu claimed to have attended in 1977 to 1979, to release his academic records, because Atiku believed that the Chicago State University certificate that Tinubu submitted to the Independent National Electoral Commission, the electoral body in charge of elections in Nigeria, was forged. And on Saturday, the courts in Illinois, under the superintendence of Justice Nancy Maldonado, sustained the ruling of a magistrate called Gilbert, magistrate court Judge Gilbert, that Chicago State University should release academic records of Bola Ahmed Tinubu. Don't forget that this very issue ought to have been released a long time ago, when Justice Gilbert gave the order, Justice Jeffrey Gilbert gave the order that Chicago State University should release these documents, Tinubu's academic documents, to Atiku Abubakar. However, Bola Ahmed Tinubu rushed to appeal against it at the court of Nancy Maldonado, claiming that if his academic records are released to Atiku Abubakar, it will cause him severe and irreparable harm. As a result, Justice Nancy Maldonado keep a hold to the order by Justice Gilbert. Now, on Saturday, that's 30th September, the court in Chicago, pretended over by Justice Nancy Maldonado, gave a ruling that those documents should be made available to Atiku Abubakar. That decision of the court has sparked excitement across the country, because many see it as an opportunity to actually find out whether what Tinubu submitted to the Independent National Electoral Commission was forged or genuine. Nigerians want to know and there, there had been excitement in Nigeria as a result of this ruling. However, a statement coming from Tinubu's lawyer, who is also the national legal advisor or former national legal advisor to the ruling All Progressive Congress and the coordinator of the presidential legal team, Babatunde Ogala, a senior advocate of Nigeria, has intervened in this matter, and what he said apparently is to dampen the spirit of those who are excited about the victory that Atiku Abubakar has gotten from the United States courts. According to Ogala, a senior advocate of Nigeria, he has said that the presidential candidate of People's Democratic Party, Alhaji Atiku Abubakar, and his supporters are only celebrating over nothing, as whatever documents that will be released by Chicago State University can no longer be useful or can no longer be used. Now, this his assertion came to light through Bayo Nanoga, and Bayo Nanoga is one of the spokespersons of Tinubu Shetima Presidential Campaign Council. He made this known in a tweet on his official Twitter handle. And of course, like I said earlier on, the court has ordered the Chicago State University to make these Tinubu's academic documents available to Atiku Abubakar latest by Tuesday. That's October 2nd. And that is based on the order of Nancy Maldonado. Like I said earlier, also, Nancy Maldonado also upheld the September 28th ruling of Judge Jeffrey Gilbert, who ordered the Chicago State University to release the Tinubu's academic records as requested by Atiku Abubakar, stressing that the PDP candidate had the right to have access to the records. Now, why this thing is very interesting is because Tinubu had pleaded severe and irreparable damage or harm to him, which was the thing that rattled the Justice Nancy Maldonado that made her to keep the thing on hold. And she has gone to reflect over it and everything else. And she was not buying into it. Okay? He was not buying into it. And as I said, this her verdict sparked excitement. But to dampen the spirit of those who are excited, the Tinubu lawyer, speaking on behalf of Tinubu, obviously, wanted to dampen the spirit of those who are excited about this ruling. Because he wanted people not to be excited. He wanted to reduce the import of this achievement by Atiku Abubakar. And I will show where he was wrong and why he was wrong in his assertions. Because as we go into the real reason why he gave that the court will no longer accept anything from Atiku Abubakar, anything that he brings from Chicago. Now, in the Twitter handle of Bayo Nanoga, he said that the headless mob is celebrating over nothing. The documents can no longer be used. It is of no value. We have passed that stage. Now, Ogala broke down the request of Atiku to Chicago State University. Now, before I go through that breakdown of of the request of Atiku to Chicago State University. If you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. Thank you and God bless you. Now, Ogala broke down the request of Atiku to Chicago State University thus. He said some of which the school already gave to the presidential election petition court before the September 6th judgment. So he was claiming that whatever they are giving to Atiku Abubakar, the Chicago State University had already answered the questions, which was used in the September 6th judgment by Presidential Election Petition Court, in which the court dismissed Atiku and PDP's petition. Now, let us look at what he was claiming. Then I will tell you my own my takeaway from it. Number one is, according to Babatunde Ogala, he said one is whether President Tinubu attended Chicago State University. The answer is yes, he said. Second, what were his grades in school? The school had already provided that. So these are Ogala's position why the Supreme Court will not have no business receiving Atiku's whatever he is getting from Chicago State University, because some of the questions had already been answered. But is it really true? Has the questions been answered? We'll get to that. But it is important for us to also remember that Atiku, the presidential candidate, the reason why he approached the court in the United States is to compel the university to release Tinubu's academic records, because it is important for him to prove that Tinubu ab initio was not qualified to contest the election, having submitted fake documents to the Independent National Electoral Commission. So he believed that if he can get those documents, he will be able to prove it. And he had requested the documents for use to support his argument that Tinubu forged a certificate he claimed to have obtained from Chicago State University in 1979 and submitted to Nigeria's electoral body, INEC, for the election. So Atiku himself is no fool. If this thing will not be of any use, he will not waste his money trying to get it. That's one thing. But let us see the reaction of Atiku Abubakar to Ogala's claim that whatever documents Atiku gets from Chicago State University is no longer useful. And after the reaction of Atiku Abubakar to this matter, then I will give my own takeaway from Ogala's assertions. Atiku Abubakar's special assistant on public communications, Frank Shoibu, said about Babatunde Ogala's assertion. He said, ordinarily, we would not have responded to the words of a legal lullipater who has never won any landmark case in court and whose growth in the legal profession is tied to the apron spring of a Chicago bagman. However, the truth needs to be said for the sake of posterity. Louis Brandeis, U.S. Supreme Court judge, may have had Ogala in mind when he said, or when he wrote, now quoting what this Supreme Court judge in the United States, Louis Brandeis, what he said. He said, about the wickedness of people shielding wrongdoers and passing them off, or at least allowing them to pass themselves off, and then propose a remedy that if the broad light of day could be let in upon men's actions, it will purify them as the sun disinfects. Continuing, the spokesperson of Atiku said, it is unfortunate that Ogala glorifies technicality instead of justice. Ogala claimed that the victory was meaningless. So why did his principal try to block the release of his credentials if he had nothing to hide? Why did he also appeal the initial judgment? The Bible says, only the wicked run when no one chases them. Why has Tinubu been blocking the release of his academic records for nearly 30 years? Now, this is my own take on this matter. First of all, there are rules within the Supreme Court that allows for additional evidence in circumstances that that they consider judicially relevant. And I have spoken with several senior advocates of Nigeria that I don't have to mention here, and they were emphatic about it, that it is true that Supreme Court don't take evidence anyhow at this level. But when they see a compelling evidence that will do justice to a case, they use their own discretion to decide whether to accept it or not. And in my own thinking, an issue as important as forgery of certificate, alleged forgery of certificate by the president of a country or whoever wants to be the president of a country, is a serious matter. That was why the Supreme Court itself, when this matter of forgery of certificate affected the governorship candidate of the All Progressive Congress in Bayelsa State 4 years ago, the Supreme Court did not hesitate in invoking Section 137 1J of the 1999 Constitution in nullifying the election, because that section expressly stated it, that anyone who submitted forged document to the electoral body is disqualified and not qualified to participate in an election. And if the person had participated in error, the votes he got and the party got will be deemed as non-existing votes. That was exactly what played out 4 years ago in Bayelsa State by the Supreme Court. So it will be unfair to use technicality to block out evidence that Atiku will bring if he can prove truly that the person who is sitting as the president of the country forged an important document as his certificate. The whole world is watching the Supreme Court of Nigeria. And the world is a global village. They may think they will do Tinubu a favor if really that's assuming that what Atiku will bring will be remarkably different from the certificate submitted to the INEC. Already there are strong indications that it will be different because even Tinubu himself has admitted in the court in Chicago that the discrepancies was not his fault, that it was the fault of the clerk. That was why there were discrepancies in the result he submitted to INEC, which had a different logo, a different font size, grammatical errors, and which also have the signage of people who are purportedly no longer in this, who are not in the service of Chicago State University as at the time that Tinubu graduated. and all that. And Tinubu himself and his lawyer, they have not denied it, that it was different, but they only say that it is not their fault. But could the Supreme Court have accepted the deputy governor of Bayelsa if he had explained to them that the mistake in the certificate he submitted to INEC was because there was a mistake by a clerk? It's not the business of the of the courts to go and uh, rectify a problem that a candidate ought to have rectified. Because if there were changes and in all those, Tinubu as a student of the school ought to have raised an objection to it and demand that proper certificate be issued to him. If there were mistakes in it, he ought to have requested for it. Because of course we know that ignorance is not an excuse in law. It's not an excuse in law. So based on all those kind of this kind of facts, it is assumed that if Atiku Abubakar brings it and it is similar and the same thing that this Chicago State University issued to Barrister Mike Enahoreba, then the matter is closed because it will be different from the certificate that Tinubu submitted, and then the Supreme Court will have no choice but to do the needful. But if Tinubu camp they are celebrating because of technicality, because obviously what Ogala is celebrating is technicality. They don't care about the justice, as Atiku Abubakar pointed out. They don't care about justice. Or they are looking for technicality. Perhaps that was why they had been intervening to delay the process so that they can use technicality to knock it off. And we just pray that the Supreme Court will not act like the Presidential Election Petition Court that was literally regurgitating the position of Tinubu's Presidential Election Petition Court. That's the lawyers of Tinubu's team. Because if you look at the most of the judgments that came out from the Presidential Election Petition Court, it was just similar to the final written address of the legal team of Tinubu. The way they dismissed FCT was similar to what these people also put in their final written address. That there's nothing special about FCT. FCT is no different from any other state and all that. Go and read the final written address of President Tinubu's legal team. Just the same way, the argument was exactly what was literally regurgitated by the Presidential Election Petition Court. So we hope that this thing that Ogala said will not be regurgitated by the Supreme Court, meaning that they will buy into the technicality, because what Ogala said is what they are going to submit in the court. That it has already, the time has passed, means technicality. Remember that when this matter started at the Presidential Election Petition Court, the chairman of that court, or the president of that court, the chairman of that panel, Samani, he was very clear that they are not going to invoke technicality. But at the end of the day, when you listen to their judgment, so much technicalities. So if the Supreme Court followed that route, then I'm afraid Nigerians may get the same kind of result from presidential election petition, from the presidential election petition court. Because what you see Ogala said, just mark it very well. Because this Ogala is part of is the coordinating, is the coordinator of Tinubu's presidential legal team. He had been in US and all that over this same matter in the court in US. So watch his argument very carefully. so that we will see whether the Supreme Court will regurgitate it, that it is past. The time is no longer useful. Now, let us also look at the other argument the Ogala made. He claimed that the question that Atiku Abubakar is looking for had already been answered at the Presidential Election Petition Court. He said one is whether Tinubu attended Chicago State University. Now, that is not the issue. Atiku Abubakar is not interested in whether Tinubu attended Chicago State University. Even at the Presidential Election Petition, even at the court in Northern District of Illinois, the Chicago State University admitted that he attended the university. Okay? That he attended the university. But the same university said that they cannot swear under oath that the certificate that Tinubu presented to INEC came from them. So they said they don't know where he got that certificate. That alone is the end of the matter. That a university who is an issuing authority say he don't know where their former student got a certificate that he presented to INEC. So the issue of attending Chicago State University is unimportant to this matter. It is not the issue at stake. It is about the certificate submitted to INEC. That is what is the bone of contention. So Ogala saying that this question had been answered is an irrelevant question to the matter at stake. It's an irrelevant question to the matter, or irrelevant answer to the matter at stake, because already the university admitted he was their student, but the certificate, they don't know where he got it from. Now, second, he said, what were his grades in school? Nobody was interested in his grade. He said the school had already provided that. Atiku Abubakar was not looking for his grade. Atiku was looking for identity matters. Is the person that owns the certificate male or female? Is the certificate that was submitted to INEC real? Was it authentic? That was why if you go and see the plea of Atiku at the court in Chicago, he demanded that they should give him the replica of the certificate that was issued to Bola Ahmed Tinubu in 1979. The real one that was issued to him, which was similar to the one that was issued by the same university under subpoena, issued to Mike Nahore Eba. And when he lays his hand on it, that will be the game changer. And not about his grade. His grade is immaterial. It is about the certificate submitted to INEC. That it is the certificate submitted to INEC that Section 137, 1J of the 1999 Constitution is interested in. Not about the person's grade. The grade of the certificate is immaterial. It is it forged? Is it authentic? That is what Atiku wants to prove before the Supreme Court. So, Ogala and Bayon and Oga should stop celebrating yet until we see what the Supreme Court will do, whether they will admit this as evidence. If they admit it and not block it through technicalities, then I don't see how the president will be able to escape from this. So the only thing that can save him now is like what Ogala is saying. If the Supreme Court uses technicality to block it so that they can't receive it. But whose interest is it served? Is it the interest of the nation or the interest of one man? That's a question that we will answer when the Supreme Court gives its verdict on the document or the certificate that Atiku will bring and is compared with what Tinubu submitted to the Independent National Electoral Commission. Thank you for watching this video. And if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, God will rank it high and recommend it for more people. Thank you, and God bless you and yours.